Well, ladies and gentlemen, welcome back to another exciting edition of Drinks with the Major and the Captain. This is Major Cosmo Taormina. I'm Captain Stephen Lieberman. We are law partners of the law firm of Lieberman and Taormina. And occasionally we have these little soirees where we smoke expensive cigars and drink expensive whiskey and either celebrate a court case that just recently was handed down or bitch bitch about a court case that just came out. And unfortunately, we're probably in the bitching category on this one. That being said, it is all is not lost. There is some that potentially puts us into a good position for a Supreme Court review, which we'll talk about to begin with. So kind of the format of the way this is going to go, Cosmo and I are going to sort of lend our analysis to the case of Young v. Hawaii that the Ninth Circuit just recently came down with. We tend to talk over each other quite frequently, so we apologize for that to begin with. We'll go for probably about maybe a half an hour or 45 minutes, depending on, how inebriated we are. Right. And then we'll open it up for questions. One thing that I am going to ask you guys to do, if you do have a question, something that we've been talking about, or it could be something candidly even unrelated to Young v. Hawaii that you want us to address, if you could use the chat box function and write your question into the chat box, Sandy is going to bring them. And as we get to the, we'll call it the open forum time, for lack of a better term, Sandy will be the first one to actually go through and start asking us questions. So if you have something pressing, go ahead and write it in the chat box, and Sandy will be your advocate later on. All right, so a little bit about the case of Young v. Hawaii.
Well, first off, tell them it's a 215-page opinion. I keep holding it up just so you guys can see. This is what it looks like printed out. 215 pages of self-flagellation by the Ninth Circuit en banc Court of Appeal. It's stunning. We've had
that includes the dissents, the two dissents, which are not bad. But let's talk about the turn of Young so that you guys can kind of understand what the case was about. So in Hawaii, contrary, very different from California, but in Hawaii, they have a legislative scheme to the bearing of arms of the home. Now, I'm going to kind of, editorialize here for a second. I think everybody in this class tonight or this session tonight would agree that the Second Amendment is very clear on what it protects. It says that you have an unfettered right to keep and bear arms. Those two sections are very important. There's been all sorts of scholarship on the prefatory clause of the Second Amendment talking about a militia. But in this particular context, one of the reasons why there is not a tremendous amount of scholarship on the keep and bear concept is that it's fairly self-explanatory. You don't have to come to the party with a bunch of pre-existing knowledge to know that to keep arms means that you have them in your home. To bear arms means that you are taking them outside. And according to the ratifiers of the Second Amendment, to keep and bear arms is a right, a pre-existing right to the formulation of the Constitution itself. So, take us to Hawaii. In Hawaii, they have a legislative scheme. They say if anybody wants to take a firearm outside of their home, other than, taking it to the range to go shooting or doing whatever, if somebody wants to carry a firearm, they essentially have two ways of doing it. They can do it concealed or they can do it openly, where people can actually see the firearm. For both methods of carry, the state of Hawaii has developed an application process. Now, the major, go ahead.
Well, the point is, the application process requires a good cause statement. That is, the individual must show, very similar in the same rationale as Peruta for us CCW holders in California, that you got to show good cause. You have to show that you are subject to some type of danger that the cops would not be able to respond to in enough time. And you have to be a good, sound moral character, pass background check, etc. There is only those two methodologies of practicing the bear portion of the arms. Now, to give you guys a little more context on this, the Ninth Circuit does not recognize that we have a constitutional right to bear a weapon outside of the home. Their entire opinion is predicated on that fact, and they use Heller in the strangest and most twisted logical way possible to buttress that
that argument.
Yeah,
but let's wait till we get into that, because again, I want to go back to the fact pattern. So Mr. Young, a resident of Hilo, Hawaii, wants to carry a firearm outside of his home. He really doesn't care whether or not he has a permit to concealed carry or to open carry. It's not really relevant to him. In fact, he applies for both. Now, his lawsuit is only predicated on the fact that he was not given a permit for the open carriage of the firearm. As it turns out, he wasn't allowed to conceal carry either, but he argues about the open carry requirement. And during the discovery process in the underlying lawsuit, one of the things that he discovers is that Hawaii has never issued a permit for open carry and never issued a permit for concealed carry
to private citizens.
Yeah, to private citizens.
They've issued them to security guards and other military, other personnel, but not a private citizen.
And not somebody who's interested in simply protecting himself against crime. So he sues. And one of the arguments in his lawsuit is that the Second Amendment to the Constitution, which has been ratified into state constitutions via the 14th Amendment, thank you, Heller versus the District of Columbia, is, is basically McDonald versus Chicago, which is basically in violation, since he has this right to bear arms, and yet Hawaii is effectively preventing him from bearing arms because they will not issue him a permit to bear arms, either concealed or openly. He loses at the trial court level. He then appeals to the Ninth Circuit Court of Appeals, where he wins under a 3-judge panel, an opinion that's drafted by Justice O'Scanlan. Incidentally, the same justice that wrote the original Peruta decision in the 3-judge panel. And in it, he says, hey, listen, Mr. Young has to have some way of exercising his right to carry a gun. It doesn't have to be open. It could be concealed. We really don't care, but he has to have some way of doing so. The court grants this under the 3-judge panel and then moves for an en banc review. Whenever they move for an en banc review, there's a high probability that they're going to overturn the 3-judge decision. Justice Baby issues her decision, and in it, and Cosmo was starting to discuss this, she undergoes a historical analysis of the Second Amendment from the standpoint of regulation of carriage. And this is really nuanced, but kind of important. Whenever we analyze a Second Amendment case, there's a big question as to what type of constitutional test we're going to employ. All right, does the state have to show that there is a compelling state interest for the statute? And are there no less restrictive alternatives? Or does the state only have to show that there's a rational basis for the statute and that or a legitimate basis for the statute with a rational relationship between the statute and the conduct that they're trying to regulate? These courts have developed an intermediate test that talks about a rational relationship with a reasonable fit. Point is that in Heller, I know I'm getting a little wonky on you guys, and I apologize, but in Heller, Justice Scalia said that certain long-standing traditions of regulations are presumptively lawful. All right. Now, what he was really saying was, if the United States of America has had this long-standing tradition that weapons should not be carried into saloons. All right, which, you know, we've had that. Yeah.
We have felons can't bear arms.
Felons,
you can't
yeah.
bring firearms onto federal property, like courthouses and other certain things like that. Those long-standing traditions will be presumptively upheld as constitutional.
But presumptively. That doesn't mean that it's, you know, we take a priori knowledge that it's going to be, you know, upheld. It's just the presumption is it has, and then the moving party has as an obligation to rebut that presumption with empirical evidence to the contrary. In this particular case, Justice Baby says, well, Baby says effectively, look, the Second Amendment, and there, if we look at a historical analysis going all the way back to the Statute of Northampton, incidentally the same statute that Justice Scalia uses as his starting off point in Heller. And that's what I really think. I really think that the entire purpose of the decision in in Young was a means of basically giving the finger to the Supreme Court in the Heller decision. I think when they looked at the historical analysis that said, hey, look, people have a right to bear arms, it pissed off all liberal courts. All right. So what she did was essentially say, hey, you know what? I'm going to do the same exacting historical analysis, but I'm going to come to an entire different conclusion. I'm going to twist the history to fit my theory. And it's a poorly done historical analysis. But one of the things that she says is, hey, look, the government has always restricted the carriage of firearms. Now, the reality was the government was typically restricting the carriage of firearms when they thought that the government was about to be overthrown because of the carriage of firearms, okay? I mean, the battle at Lexington and Concord, which she conveniently left out, was an exercise in British gun control, all right? We started a revolution as a result of this whole thing. So she leaves this stuff out. What she essentially says is, look, people, you know, the state has been regulating firearms for years, for decades, for centuries. And in fact, for those of you who get all hot and bothered because there's certain local municipalities that mandate that people hold firearms, well, that works for us too, because the state telling you you have to do something is the functional equivalent to the state telling you you cannot do something. So since we've got all these long-standing traditions, go ahead.
Well, the idea was if you use history as your model to justify something, you can always find some historical precedent in the past where if it happened once, you can use it to justify what's happening now. And one of our heroines, Justice Consuelo Callahan, of the Seraphim,
we love her.
We love her. Yeah. Yes, she was one of the justices that struck down the ammunition law. She was one of the justices that struck down the magazine prohibition. She's one of the good ones. She pointed this out.
And she has really good eyewear.
Yeah, she does.
She wears really good glasses.
Big, giant glasses with the little rhinestones around them. We love her.
She's like a good Ruth Bader Ginsburg.
You know, the next time we should we should bring our own glasses next time we do this. But the idea was, if you're going to use history to justify, you can use that to just anything. And under the same rubric that they've applied, then there's been a long-standing tradition in America.
Well, let's hold the table that.
Hold on,
let's table that for a second. Let's table that for a second, because that's the money line here, right at the end.
Yeah.
So here's the deal. She sits there and she says, okay, you know, we've got all these principal regulations, and since Scalia said that the first part of the analysis is, are there long-standing traditions, therefore they're going to be presumptively lawful, we don't have to actually analyze whether the Second Amendment is in fact implicated. We get to sit there and essentially say, well, you know what? Since there's all these regulations in Hawaii, since the time Hawaii was formed as a state, and actually even preceding that, whether or not Mr. Young is being deprived his Second Amendment rights is somewhat an irrelevant question. The real question is whether these long traditions have been in place. Since they have, we are going to naturally presume they're lawful. Therefore, we're going to find that the trial court made no error in discretion and, in fact, granting relief to the state.
One of the things that Callahan tried to get them back to was whether or not the restrictions in Hawaii fundamentally affected what they call the core Second Amendment right. Now, the majority opinion that controlled neatly avoided this by saying, no. Just like the captain was saying, we're never even going to get to a Second Amendment analysis by simply saying, since it's a long-standing tradition of infringing upon the Second Amendment, therefore, we don't even have to analyze whether or not it's core to the Second Amendment, what level of scrutiny it applies. We have to do none of that analysis, and we're not going to. And they didn't.
So here's the biggie.
Yeah.
All right. Since this is now a case out of the Ninth Circuit with precedential value, you can now cite this as authority in going after other cases. Let's talk about other constitutional rights that have had long-standing traditions of regulation. All right, things like
voting by chance,
gay marriage,
and gay marriage,
abortion. Yeah, right. So now somebody can file a lawsuit about, essentially allowing the Civil Rights Act of 1968 to go through with voting, saying, hey, Ninth Circuit said that there's been long-standing traditions, and since this goes against those long-standing traditions, done. Okay, gay marriage, look to Young versus Hawaii. Fact of the matter is, we've had long-standing traditions of regulations that only a man and a woman can be married. Anything that goes beyond that is by definition unconstitutional. So therefore, we don't even have to discuss whether or not there's equal protection issues or whether or not somebody's achieving proper due process, because we've had these long-standing traditions.
The disenfranchising of certain minority groups because from the voting acts, since there's been a long-standing tradition of that, why do we have to analyze whether or not it's constitutional or not? Why don't we just lump them into the same rubric that Young versus Hawaii uses and said, since there's a long-standing tradition, we never even cross the threshold of a constitutional analysis.
In fact, why limit us to this? Right. Let's go back in time. All right. Dred Scott. All right. Dred Scott did nothing more than codify long-standing traditions that slaves were properties. Okay. The 13th Amendment, by definition, is something that should never have been ratified. We have to go back to the original thing because, again, long-standing traditions, right? The whole thing is such utter garbage.
If this was a law school paper and I was a professor, the Ninth Circuit would get an F- for missing the entire point. To go to an argument that is a logical fallacy of appeal to tradition by ignoring their duties to go through and doing a correct and robust analysis over the Second Amendment as applied today. To look at it from another perspective, the language that used in the First Amendment, that Congress shall make no law respecting the establishment of a religion or prohibiting the free thereof, or respecting I'm forgetting it now, but freedom of speech and the freedom of press. When they talked about press, they truly meant a printing press, because broadcast media, art, film, radio, none of those things existed at the time. And now, of course, we have encompassed those as requiring First Amendment protection. This throws all of that out. Basically says longstanding tradition. The words say printing press. Therefore, if it's not a book or a magazine, it covers no constitutional protection. And they've opened it up to going back to that level of analysis.
Let's look at it for something that could directly affect you guys. Let's talk about something like privacy in your home. Okay, you have a Fourth Amendment. Well, until the Supreme Court gets rid of it, you have a Fourth Amendment protection to what could best be construed as privacy, okay? In the penumbras. Okay?
Penumbras. So I would say it was a Third Amendment loss, but anyway.
Yeah. So anyways, you got this, we are supposed to be secured in our homes and our persons, right? So there is a long-standing tradition of regulating, essentially saying that law enforcement can simply walk into your home without having a warrant and search for anything at any time. Okay, we have decades of unconstitutional statutes.
It was that way in this country until 1776.
Yeah. So we've got literally actually centuries of statutes, okay, that effectively say there is no such thing as a Fourth Amendment protection. So cop comes into Kevin Korff's house, all right, does so without, Kevin sits there and says, hey, all of the marijuana, well, marijuana is legal now, all of the heroin that you found in plain view on my counter, that cannot come into trial as evidence because my Fourth Amendment rights were violated based on an illegal search. It goes to the Ninth Circuit Court of Appeals, and Kevin essentially says, hey, court, there either is a Fourth Amendment that protects me against unreasonable searches and seizures, or there is no Fourth Amendment. You can make a declarative statement that says the Fourth Amendment no longer exists. And the court says, Kevin, we do not have to actually say either. We can simply say, because there have been these statutes that say cops can do whatever they want and they can come into your home whether there's a warrant or not is irrelevant. Because we've had all these long-standing statutes, they are presumptively lawful. So we don't even have to make a decision as to whether or not the Fourth Amendment was violated in the case.
The true crap about this Ninth Circuit decision is a lot of the rights that are codified and enshrined in our Constitution as something the government's supposed to protect only are found and enshrined in the United States. So when they go outside of our country's borders and start talking about, hey, how there's been centuries of oppression all over the world and no one's allowed to keep the gun in Australia, England, pick a country. Therefore, those long-standing traditions of infringement, well, we shouldn't buck the system. We should simply go along with it too. Ignore the Constitution, ignore the Revolutionary War, and how we broke away from all those other monarchy models and all those other proletariat models.
Even broader than that, okay? Where I will ask the major, and he knows the answer, so rights are universal. Rights do not exist exclusively in the United States. So when they sit there and they look at other countries that do not understand that rights come from God, that do not understand that rights are pre-existing to either our Constitution or the other constitutions.
Wow.
Trying to do utterly worthless. It has no dispositive value at all.
These traditions of infringement, these traditions of repression, these traditions of tyranny have no place in the United States. We broke off from all of that. We said that the government's job, and its only job, is to protect the rights that we, the citizens, deem we have. And there are a lot of them. And they number more than 10.
Yeah, we don't know how many there are.
We don't know how many there are. There could be more in the future. The point is, the Ninth Circuit saying that an appeal to tradition, to infringe upon a right, therefore justifies the is completely and totally unconstitutional, and it's un-American.
So the good news is that there is now a circuit court split. The Fifth Circuit and the Ninth Circuit have an entirely different interpretation of what the Second Amendment actually means. And the pathway to the Supreme Court is through a circuit split. That is the easiest way to get there because philosophically you have two circuits that look at a fundamental nature of the Constitution at in a 180-degree difference. Now, we do have a lot of people, and I've gotten multiple phone calls and emails over the last week or so from people saying, do I need to turn in my CCW permit? Am I still going to be able to carry my gun? You know, blah, 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 blah. The answer to that question is, of course, you are still entitled. You know, the state theoretically, now this would be interesting to see if the state actually tried to jump on this, but the state theoretically, now knowing that the Second Amendment is no longer something that can be used as a legitimate argument for somebody's rights under a Ninth Circuit analysis, state of California could say, you know what, all guns are gone. Okay, you could try to do that. And based on long-standing traditions, they might be able to actually win. But I don't see the state actually attempting to do that. That would probably cause a revolution in the country and state. More than that, our local sheriffs, people that have issued CCW permits and things like they've got no positive obligation to start rescinding or do anything else. The Ninth Circuit did not tell any government agency, you must not give permits, you must confiscate firearms or anything along those lines. It's not a positive declaration. What it essentially says is, hey, you know what? If the state wants to restrict firearms, they're going to be able to get away with it because as long as there's these long-standing traditions, a plaintiff is never going to be able to pierce that wall and be able to get into the real meat of the question as to whether or not the Second Amendment protects a right to keep and bear arms.
Speaking, the practical effect of Young was to uphold Hawaii's statutory scheme to require a permit to open or concealed carry upon a showing of good cause and a special need. That regulatory scheme has been upheld. Therefore, the regulatory schemes that we have here in California, where we apply to get a permit, who then issues it to us based upon the application process, which, as we all know, good cause statement, has been upheld constitutional. Actually, they never even
got there. Yeah,
they just basically said it's fine.
Yeah, what they did was
the connection is unstable. All right, we're still good. You haven't frozen.
What they effectively did was they said, like we're going to take the Constitution and we're going to take it and we're going to put it behind a wall. And
we're going to ignore it.
Yeah, we're going to put it behind a wall. And before you are able to argue a violation of your rights, first you've got to tear down the wall of pre-existing, long-standing traditions. If you can get through that, then you can actually get to a question as to whether or not the constitutional right actually exists.
That's what got into that whole core amendment, Second Amendment right. What is the core of the Second Amendment that it protects? Now, leading the plain language of the amendment, it's easy to see that it's to keep and bear. That is to keep in your person, to bear outside of the home. Think about the Minutemen who had their rifles above their mantles on their fireplaces, and when the bell rang, they would grab their rifle, their shot, and their powder and muster in the town square. Because remember, the founders were very suspicious of a standing army, because that's how the British kept control. They didn't have a police force, they had the army. And the army, in essence, occupied whatever town, region, country that the British wanted to extend control over.
You're going to get into the Third Amendment.
I am going to get into the Third Amendment, because that is truly where the privacy right lies. Yeah, those of you who know me, I'm familiar with my work. The Third Amendment, it really is a larger amendment applied practically than it actually says. For those of you who don't know, the Third Amendment says that the government will not quarter soldiers in your homes. But think about what that really should mean. The government can't have an agent in your home. The government can't be listening to you while you're at home. In the Revolution, or before the Revolution, they would quarter British soldiers in homes. It kept down insurrection, and it also saved a lot of money. But think about what that really meant. You had an agent of the government joining you at your dinner table, seeing what persons came to visit you, looking at the reading materials that you were reading, and listening to your conversations between your spouse. An agent of the government who was duty-bound to report any seditious behavior or any infraction of the law that he happened to see.
Are you talking about a right to privacy, Major?
I am talking about a right to privacy. So any of you guys who out there have got an Amazon Echo or Google Point, all that, should get rid of that crap. Because as you know, those private tech companies are sharing all the information with the government.
So
don't give them a window into your home.
The good Catholic pro-life Major over here actually agrees with Roe v. Wade. He just thinks that they use the wrong amendment to yeah.
We'd have to get into a tangent on that one, whether or not a right to privacy exists on that score. But
in any event, getting back to it, fact of the matter is we now have a circuit court split, which means this is going to definitely be up for a Supreme Court review. My suspicion is they're probably going to hear this next term. We already have the court now looking at New York Rifle and Pistol again. That has made its way back, and that's going to be reviewed. It's entirely possible that Young v. Hawaii also gets wrapped up into the bundle with this whole thing. I think that the court is going to issue a decision next spring, probably a year from now, where they are going to say that it is a core right, it is subject to strict scrutiny, and that it's a muscular right, the same level of muscularness that the First Amendment has. All right.
Even though the First Amendment's under attack, but that's a different
issue. That's a different thing. And
we're hoping that we'll see on that score, on that particular decision, we're hoping to see Gorsuch, we're hoping to see Kavanaugh, we're hoping to see Justice Thomas, we're hoping to see Justice Alito, and we're hoping to see Justice Barrett being in the majority and upholding the Second Amendment right as a core right, and the subject of any review should be strict scrutiny. And it exists outside of the home, and this whole historical analysis crap goes out the window. That's what we're hoping. That's who we're hoping to see on the panel. That's what we're hoping to see.
And I think there's a extraordinarily good chance that we'll have that. Once we have that, a lot of our California gun control laws suddenly become subject to challenge. All right. With that, we've pontificated long enough.
Yes.
Sandy, would you like to chime in and as you drink your whiskey and tell us some of the questions that have been proffered to us?
Yes, in order. Scott asked, should we as the citizens of the USA be able to expect a rational jurist on the circuit courts? And how can they promote and implement such baseless decisions?
Oh, that's actually, that's good. That's good.
Wow.
So here's the thing.
How much time do you want to suspend on that?
I'm going to give you a real baseline answer. Okay. Elections have consequences. They really do. Okay. When you have individuals that sit there and say, well, I'm not going to vote for Trump because, I don't like his personality, right? I don't like what he did on particular things. Well, the fact of the matter is that's fine. Whether or not you vote for Biden or you don't vote at all, notwithstanding election fraud and everything else. The fact of the matter is, whoever ultimately gets control of power has the absolute right to put in jurists that are aligned with their judicial philosophy. The problem that we've had with the left, we don't seem to have it so much with the right. The problem that we have with the left is that they are what we would call outcome determinative jurists. Okay, what they do is they look at a problem that's been presented to the court and they say, in our social justice mentality, irrespective of the Constitution, in our social justice mentality, what kind of objective are we looking to achieve? Well, we don't want people to bear arms outside of their home. We don't like guns. We don't like guns being in the public square. So our decision has to be that we're going to uphold the Hawaii statutes. We want to keep these guns out of the hands of people. So now, what type of intellectual gymnastics do we have to go through in order to achieve that objective? In Young, I got to give him credit. In Young, rather than sitting there and trying to twist the Second Amendment, they realized they had essentially been boxed in. So instead, they just simply said, "We're not even going to analyze the Second Amendment. We're gonna jump ahead of it. We're gonna
say it doesn't even apply.
Yeah, we're gonna knock it out before we even get there." So ultimately speaking, and this is why the major asks, how much time do you have? The one thing that unites a country, in fact, a country cannot exist unless it has a strong judiciary. And that judiciary has to be, for the most part, considered impartial, because you now have predictability. I will not lend money to Cosmo if I feel that the contract that we develop, if it's in breach one way or the other, if it goes before a court, whoever pays the most money or whoever happens to be of the right political persuasion is going to get the decision in their favor. Because if the court is so subject to exterior whims, then I have no predictability in how the court is going to rule. And if I have no predictability, I don't have the confidence to make a contract and have a hedge against a failure of the contract.
This is why it's so hard to do business in other countries. This is why it's hard to do business in Mexico. This is why it's hard to do business in China. This is why it's hard to do business anywhere else, because the courts are subject to bribery. They're subject to whim. They're subject to other partial things that don't factor into the actual facts before the court and the statutes that were written.
So
this is the issue.
So in all honesty, people sit there and they look at the who's running for president of the United States, and everybody gets their panties in a bunch about that. People look at individual senator house races and they get their panties in a bunch about that. I am far more concerned about systemic failure of the judiciary. Now, granted, we're both lawyers, but I'm far more concerned about systemic failures of the judiciary than I am, candidly, about Congress or the executive branch of government, because the judiciary is our last hope for an actual civilization. Right. So anyways,
we need to have the predictability. We need to have the impartiality. We need to have a case body of precedent that will give us some degree of predictability in the future. Is that this type of case in this type of court, it's going to produce this type of result. There will always be deviations on one side or the other, extremes.
And there'll always be injustice.
Yes, and there'll always be injustice.
Yeah.
But if the most part of it doesn't happen that way, we have a stable system. We're seeing the undermining where they decide they want to have a result and then work their way backwards from it. The way so far is to ignore the Constitution.
They're an unelected third, essentially political branch of government. All right, Sandy.
Question number 2 comes from Christy. I just read in one of the magazines, maybe NRA, there are several circuits that have a split on some level with this. Sorry, that was a comment and not a question.
Well, she's absolutely correct. That is true.
That's going to get us into the Supreme Court, we hope.
Yeah.
Carol, your hand was up. Is it still up, or where are you, Carol? There she is. Nope, she doesn't have a question. Michael Templeton asks, what is the Fifth Circuit case site that is in conflict with Young and provides a pathway to SCOTUS?
It's Wren. It's Wren.
Ernie has a statement. The good thing about CCW in California is that issuing authority has been delegated down to the county sheriff. So even if the state nixed CCW in California, the door is open to the individual sheriff to tell them to piss off.
Not entirely. Okay, so you've got to remember that the CCW is based on a California Penal Code statute. Okay, DOJ promulgates certain regulations as it relates to the issuance of a CCW, but they vest the power to issue the CCW in the county. Well, actually, it's not in the county sheriff; it's the chief law enforcement officer of any jurisdiction. So, there's a lot of police chiefs that actually give CCWs. So if the state legislature were to, and by the way, this would never happen, I'll explain why in a second. If the state legislature were to say, we're going to just simply say we do not give out CCWs in California, and by definition, all of the power to issue a permit would be completely removed from the county sheriff or the chief of.
You saw this happen to Alex Villanueva, the sheriff of LA County during COVID, where he says, I don't care what's going on. I'm closing down the gun stores.
Well, but this is actually coming from the state rather than going down to him. Now, here's the reason that it would never happen. Okay. It's not just regular Joes like you and me that have CCWs. There's also judicial permits. There's a lot of federal officers that have permits. There's a
retired law enforcement.
There's celebrities, things like that. Politicians have CCW permits. If they were to say by statute that they are rescinding permits, but then they excluded those individuals, they'd have a revolution on their hands. It wouldn't happen. Okay, and what they would ultimately do is they would say we're getting rid of all permitting at all, and then as a result of that, you'd have a bunch that would say, fine, not a problem. We're not going to issue search warrants. They have the right to do that. Okay, so
they can simply find that the statement of probable cause delivered before a neutral magistrate doesn't meet the standard probable cause in their
which
mind.
Usually it doesn't.
It does. Usually they issue every permit, every warrant issued before that.
The fact of the matter is, then we saw this actually. We saw the sheriff in LA County wanting to not give permits, not give permits to judges, and the judges said, not a problem. We're not going to issue any probable cause warrants for searches and seizures. And quickly they changed their position and started reissuing permits to judges. So go figure. That's that whole checks and balances thing. So in any event, Sandy, got another one?
All right. So Olaf wants to ensure that the worst case scenario is we lose our CCW permits, and the best case is nothing changes, right?
I would say that I think that's actually probably accurate. I mean, the worst case scenario would be actually more than that. The worst case scenario would potentially be a loss of CCWs compounded with actual confiscation of firearms. I mean, the legislature, based on a theory that the Second Amendment is no longer potentially enforceable in the Ninth Circuit, could theoretically say, we're going to take this opportunity to confiscate all firearms because we consider them contraband. And since we have a long-standing tradition of regulating firearms, this is presumptively lawful, and everybody turn in your guns. As Dianne Feinstein said, Mr. and Mrs. American turning your firearm.
You know, Young Hawaii never defined how long a long-standing tradition would have.
Interesting how they did that, right?
Yeah, they went right around it. They're talking about centuries. Well, California's been a state since 1846. 1846? So, yeah. When,
no, it was after that.
1850?
1850, yeah.
Okay, since 1850. So we're looking at what, 170 some odd years? 170-year tradition of infringing upon your rights. Therefore, under their rubric, any regulation that the state legislature were to come up with would fit neatly under that umbrella. And I believe that's what they're also setting up for anything that challenges them. They'll just suddenly cite to Young and say, there's been a long-standing tradition on it, therefore, we're not even going to consider it.
What is interesting is that I can see a potential problem with Duncan v. Becerra on our magazines, right? Because after all, we had a long-standing tradition since the late 90s of regulating standard capacity magazines. And they may try to use Young as some sort of mechanism. Yeah, you know what? Benitez did a really wonderful job of articulating the Second Amendment in his original decision. And you know what? The three-judge panel did a pretty good job of that too. The problem is there was never a need to get to a Second Amendment analysis. Fact is that we had a long-standing tradition of regulations, therefore they're presumptively lawful.
Yeah, it's been 21 years.
Yeah,
what's your complaint? It's been 21 years of this. There we go.
So worst case scenario, we're all going fishing is what you're saying.
Yeah,
there
right.
There you go. A lot of charter boats going out there.
All right, so Scott wants to know about packing the court scheme.
So
that's an
interesting. I am, well, okay. The major may not share my belief on this one. I find it very, very unlikely that the Democrats are going to attempt to pack the court.
I agree.
There's a couple of reasons for this. First reason is that I think there are a lot of Democrats in Congress that would find it distasteful. I don't think that they would be able to secure enough votes to be able to achieve their desired end. Second thing is it smacks of intense desperation. It would essentially show the Democrats as being a party that's about to literally run out of gas. Because if they pack the courts with a Democratic majority in Congress, then the courts will be further packed with a Republican majority. And that will absolutely guarantee a Republican majority. So, you know, I don't see, I mean, theoretically speaking, you could have a 400-person Supreme Court. I know they've been floating ideas about effectively term limiting justices on the court. I'll be honest with you, I have somewhat mixed opinions on that. In this particular context, I sort of do fall towards the long-standing tradition. That being said, I do believe that it's entirely reasonable for a jurist to have a modicum of intellectual competency. We've had, instances, not just recently, we can go all the way back to the 1860s, where we've had justices that were completely lacked compos mentis. All right, but they were still sitting on the court while they were sucking air out of the world.
One judge was even removed while he was sitting on the bench. The marshals came in, lifted him in his chair, and carried him out of the courtroom.
Yeah, without any that was taking place. So maybe we have that. And again, I don't even know that it's necessarily the Supreme Court that becomes majorly at issue. We have the entire judiciary potentially implicated by that, because if you're going to pack the Supreme Court, pack the Ninth Court, why not pack the federal courts? Why do we have a single judge sitting in a U.S. district court, right? For every Trump appointee that's sitting in a federal court docket, why don't we go ahead and throw in 2 additional Biden appointees and make all decisions that come out of a federal district court a 2-to-1 decision? I mean, it's ludicrous, right? With no potential cap. So
it's a really bad look, and it destroys the predictability of the justice system.
Well, and it destroys the credibility of the party in power. So I don't see it happening.
I don't think they're concerned about how they look. You look at the stuff they're doing already in Congress, some of the power grabs.
You've got to remember, Kevin, there's still a 10th Amendment to the Constitution. And a lot of times states, and they do have the ability to do this, states can sit there and effectively say, we're not going to follow federal law. Okay, you guys came up with this ridiculous scheme as a result of court packing or whatever it is, And you know what? Rock on. We're simply not going to follow it.
Look at the marijuana laws.
Yeah, look at California.
Look
we
at
did
the
it.
marijuana.
Yeah.
There's your perfect example. The feds still have it as a Schedule 1 substance. And all the states that have legalized it have turned to the feds and say, you enforce it.
Yeah, go for it. You know, we don't really care. You know, what's to stop Alabama, Tennessee, Arkansas, Texas, right, from sitting there and saying, yeah, you know what? Sounds great idea, guys. Love that you've gone ahead and you've decided to pack the court. We're not going to seat any judges. You know, well, I mean, it really can rip the fabric of the country apart. You know, and I think they know that. You know, a lot of power is predicated tacit assumption that people are in fact going to follow you. You know, and if people aren't going to follow you, you lose all power. George Orwell said it best. The single biggest fear that the British colonial, government had was that their colonists would laugh at them. You know, that was the biggest fear. If the minute the countries that the British Empire was colonizing started to look at the British as humorous, the end of the empire was at hand, because then they would independently make decisions as to whether they were going to follow imperial edicts.
What we have is this problem right now where the government's been emboldened, both state and federal alike, by the fact that they were successfully able to shut down the entire economy for a year based upon this pandemic. Now, without getting into the pandemic, the fact that they were able to do that, they were able to quarantine healthy people when there's a case from the United States Supreme Court from 1900 that says you cannot quarantine healthy people. Period. End of story. Full stop. That's the holding. Right line law. And they did it anyway. And people went along with it. That's where they're getting their courage from. That's what they're borrowing from. We've already infringed upon your rights to a degree never seen before in the history of man. And now you're going to be upset about a couple of judges on a bench?
We have a Supreme Court oral argument that just took place on the Fourth Amendment to the Constitution, okay, where the court is seriously considering whether or not the Fourth Amendment even exists, you know, whether or not it's been so incredibly gutted that there's no point in even having a Fourth Amendment anymore. The only justice that literally one, well, potentially Thomas, we don't know because he doesn't say much, but the only justice that really gave a full-throated defense to the Fourth Amendment is my spirit animal, Neil Gorsuch. Okay, but outside of him, I mean, we've got a whole bunch of very intellectual justices, including Amy Coney Barrett, who are sitting there going, "Oh, you know, I mean, the Fourth Amendment. A lot of bad people get away with things because of the Fourth Amendment. Who gives a fuck? I mean, that's part of the Constitution."
Remember, Blackstone said at one point it was better for 10 guilty people to go innocent than for one innocent person to be convicted. That's flopped. They'd rather see 10 guilty people go and one innocent person go than let any of them off.
Wow.
Given what you said right there, it sounds exactly what the Ninth Circuit said as far as the Second Amendment.
Yeah,
So if they follow their same moniker for the, Fourth Amendment, they apply it to the Second, then we're following what the Ninth Circuit said. It's the end of it.
Because now voting becomes a privilege. You know, exercising your right to be secure in your home is nothing more than a privilege. It suddenly gets to become incredibly comfortable saying, look, ultimately speaking, the state owns all of your property. We allow you to use it as long as it benefits the state. You know, your actions, as long as they benefit the collective, are acceptable. But the minute they violate the needs of the collective, they're no longer, going to be allowed. You know, I mean, for all intents and purposes, that's what the country has become. We're free-range humans, not even free-range humans. We're semi-caged humans that are existing for the purposes of the benefit of the state.
We're caged. We just can't see the fences because they're so far away.
Yeah.
But they're getting closer. They're getting closer.
All right, Sandy, you got something else?
Stephen, can you, or Cosmo, can you let them know what quarantine case from the 1900s?
Case is called City and County of Oakland, or not City and County of Oakland, JEW space HO. It was a Chinese immigrant. There was an outbreak of bubonic plague in Oakland, and they decided they were going to quarantine the entire Chinese quarter. And so they sued, said, hey, you can't do that. Not all of us have this disease. And the Supreme Court went all the way to the Supreme Court, says you can't do that. You can't quarantine healthy people. Not healthy people. We just threw that out. Pretended it never even existed.
So based on the marijuana example, couldn't California do the same if SCOTUS overturns the Young decision? And if so, how do we get relief?
Ah, yes, they theoretically could
do that, yes.
Right? I mean, that's absolutely possible, right? So the Supreme Court sits there. That's actually one of the biggest concerns, right? Understand something. The Supreme Court doesn't have an enforcement arm. The judiciary doesn't have an enforcement arm. There is a reason why bailiffs are part of the executive branch of government. When you go into a court, you don't have, even though we're officers of the court, okay?
Whatever that means.
Whatever that means, yeah. We do not have any enforcement mechanisms. We have to rely on the executive branch of government to actually enforce the edicts that come out of the judicial branch of government.
Specifically, if someone doesn't show up, we subpoena a witness to be present at trial or a hearing or whatever it is, and they don't show, we then have to beg the sheriff's department to go out and arrest them. The court issues a bench warrant, and then it's up to the executive branch, either the marshal or the sheriff, to go out and enforce it.
So
if they decide not to,
yeah,
then we're done.
Yeah,
we have
so,
no other mechanism.
So ultimately speaking, if the Supreme Court sit there and say, you know what, we're going to interpret the Second Amendment like the Second Amendment was intended to be interpreted, and California were to say, we don't care, yeah, there's really not a lot we can do, right?
We can scream and yell, and then we would have to rely upon all 58 law enforcement officers, 58 of the sheriff's departments, to decide what they want to do.
And there would be internal dissension. There would be internal dissension. So think about Peruta versus San Diego, right? The Ninth Circuit Court of Appeals and the 3-judge panel in Peruta sits there and says, general interest in self-defense is sufficient good cause. All right. San Diego, a party to the lawsuit, says, yeah, we don't consider it settled law. Okay, they just lost the case, right? But they're like, yeah, we don't really give a shit. You know?
Even Orange County said we're going to trace under Sheriff, what was
Hutchins.
Hutchins, she turned it around. She said, you know what, I'm going to follow the Ninth Circuit says it's good, then I'm going to issue permits. And then professor carried it on.
But again, I mean, there wasn't a state police officer knocking on, these individual county sheriff's doors saying, you've got to do this or we're going to arrest you. Yeah, there is no enforcement mechanism. And so, all right, Sandy, I think we got maybe time for 2 more and then we're going to have to cut it.
No, that's pretty much it. I mean, there's Christy had a question. It was off topic. Bear with me. Can someone explain why people are calling the voting regulations passed in Georgia racist? I don't understand.
Whoa, I didn't understand the question.
The voting regulations that were passed in Georgia, they're calling that racist. Do you know why?
Oh, yeah, because if I am potentially, irrespective of political party, okay, if my position in power is dependent on votes, then I am going to farm votes in whatever manner I possibly can. If it looks as though my conduit for the farming of votes is going to be curtailed because the other side is creating some sort of legislation that is going to prevent my group, whether they're legal or not, is immaterial. It's going to prevent them or hinder them from being able to vote. Then I am going to use whatever means is at my disposal to be able to hold on to power. All right. So the easiest way of couching terms that people understand is to simply say they're racist, right? And, if I'm sitting there saying, well, the largest expanding voter bloc is African American in Georgia, and these laws are going to potentially affect African American voters, then by logical extension, they're racist, right? If I sit there and I say, you need to have some sort of valid identification to get a COVID shot. You need to have valid identification to get on an airplane. You need to have valid identification to get a library book. But you don't have to have any identification in order to be able to vote. It's because I want those votes. And anything that blocks me from having those votes is going to be a problem for my continued existence in power. And I will do and say whatever is required to get people to believe that my voting block cannot be abrogated in any sort sense of the word. So if I have to say that it's racist, it's racist. It's sexist, it's sexist. You know, whatever.
They were
is
talking
necessary.
about in voter in Georgia that it was illegal to give someone in line water.
Well, but no,
that's not the whole.
yeah,
That's not
yeah.
the whole law. The
No.
whole law. Look, you can't give people incentives to stand in line and vote.
Or more to the point, you cannot provide value to someone in line. Okay, so what is value?
Right.
Hey,
vote. We'll give you a pizza and a beer.
We'll give you $100, right? I mean, whatever it is. You know, the fact of the matter is we go to the extreme. Oh, they won't allow giving water. Well, yes, that's factually accurate. Okay,
It's not just water. It's
but,
also the value is really what it comes down to.
But understand something. If a non-political party wants to give water to someone standing in line, that was still perfectly allowable under the law. If the Democratic Party wanted to give a bottle with a vote Democrat sticker on it or something like that, that is because that is a campaign group providing something of value. It's minor, right? But it's providing something of value. So, anyways.
Let's see.
Thank you.
Wait. I have a couple more, only a couple more. There was a question about inheriting guns or if your child is under the age of 21, can they still inherit guns?
Yes, but they may not necessarily have a possessory interest in the firearm. They can have an equitable interest in the firearm, but it has to be held in some form of trust until they turn 21 and they actually have a possessory interest in it.
So if I may jump in, Stephen, is that something we should add to our living trust?
You know, it depends on the robustness of your collection of firearms. You know,
some nice Parazzis that are worth a couple $100 grand.
Probably. Yeah, probably. You know, I mean, if you can look at your gun collection and sit there and say, wow, collectively I've got $2,000 worth of guns. Probably not. You know, I mean, but like Cosmo said, if you look at your gun collection and you're like, wow, I probably got about 40 grand worth of guns here. Yeah, you know what? Maybe it's a good idea.
So I'm wondering if I pass away and my son is inheriting the guns and he's not 21, who controls the...
Whoever the executor of the estate is.
Okay.
Just like anything else. Yeah.
Thank you.
No worries. All right. How's that for somebody who
Put
doesn't...
Stephen in charge.
That's good.
Just one quick thing. The one thing that I really like about the Second Amendment that is really kind of overlooked, not talked about, is probably the smallest part of it, and it's the period at the end. The right to keep bear arms shall not be infringed. Period.
Yeah.
That should be the end of the. That should be the end of the end of it. All this other certainty stuff is a diversion.
The nefarious brilliance of the Ninth Circuit saying, you know what, Kevin, you may be absolutely correct.
But it doesn't make any difference.
You may be absolutely correct. But before we get to that analysis pursuant to Heller, first we have to look to see if there's any long-standing traditions. Oh, look, we've got a long-standing tradition. So yeah, we're done. You know, that's that outcome determinative model. And you know, clearly that is not what Scalia was talking about. Scalia was simply saying that certain standing traditions are presumptively valid, but a tradition that essentially completely obliterates the Second Amendment is not going to be presumptively valid. You know, but that again, that notwithstanding, the Ninth Circuit had a predetermined outcome that they were looking to achieve, and they were going to twist the decision in whatever capacity was necessary in order to achieve that outcome. And so, in fact, in a lot of respects, arguing about their logic is kind of like how many angels can fit on the head of a pin. I mean, there's no logic to it, you know.
Here's one more question. Why haven't the anti-gun people taxed the guns? Taxed guns.
They're getting there. They got sales tax on them. We got a droves fee.
Yeah, I mean, in a sense, they have, right? I mean, we have firearm safety card requirements. We've got, you know, the droves fees.
which
we've
have gone
got,
up.
you know,
There's been a new law that just passed in California that says that the states can now, or the counties can now pass on to the CCW holder the actual cost of getting their license.
yeah.
And, you know, those fees will continue to go up because they never go down.
Yeah. So, I mean, there, you
I
know,
think the binder would have.
I was going to say,
think the binder would have.
well, HR 127 gets very specific. And rather than taxing an individual firearm, because after all, you know, could be ghost guns, because as soon as you tax something, there's going to be an underground market, right? So instead of taxing the individual firearm, we start taxing the individual that's going to own the firearm by giving them a license. And, you know, we're going to charge them $800 a year in order to be able to have this license. So
wait for the time when you get a county like San Francisco that says, okay, you want a CCW? We're going to charge you 25 grand for it. And we'll do it. And then the argument will be an equal protection one, because they're saying the 25 grand and up crowd can afford these things, but the people who are making less than 25 grand a year will not be able to do it.
Forget the CCW. Let's talk about guns.
Yeah.
Let's just talk about physically buying a gun, right?
The Dro's cost
of
doing the NCI, the National Criminal Instant Check. The cost of that, 50 grand.
Yeah.
Well, now you've eliminated all the poor. And now it's a disenfranchisement based on an economic analysis.
And
that is unconstitutional. Yeah. But again, we may not even get there because there's been a long-standing tradition of infringing upon your rights.
Well, I thought there was earlier on in the Biden administration. I thought there was a proposal for a $200 per gun tax.
Well, we've got legislation.
Well, it's an actual tax.
No, again, we've got HR 127 that sits there and pursues an $800 license per year. So, I mean, it already exists. You know, an executive action would probably instantly be found unconstitutional, because an executive action cannot actually create legislation. It can only be used to explain, enhance, or correct potential flaws in legislation. So, you know, a true tax or a true license would be beyond of the executive branch of government, and they sort of know that. So, you know, he issues. I mean, think about it from a political standpoint. He issues an executive order. The executive order is instantly stayed pursuant to a preliminary injunction. That preliminary injunction is ultimately goes to trial. The trial court overturns it based on the fact that, I mean, it never actually comes to fruition. So yes, he's done a lot of executive actions, just like Donald Trump did a lot of executive actions, just like Obama did a lot of executive actions. But every executive action comes with consequences too. All right, guys, hate to do this. It's 8:10. And the only way that Major Taormina is going to be able to maintain that beautiful visage that he has is by getting a requisite amount of beauty sleep. So we're going to have to we're going to have to let him go. Guys, I hope you enjoyed tonight's Drinks with the Major and the Captain. I hope that nobody's irritated. You know, we'll probably be doing this again here pretty soon. You know, I'm sure that